here. Today, I'm going to be talking about the diagnostic assessment that's needed in the family courts. And to begin with, just very simply, uh, in the family courts, parents and the courts, you have a problem and you need to fix your problem. And for that, you're going to need a treatment plan to fix your problem. Now, to get a treatment plan, you're going to need a diagnosis because the treatment for cancer is different than the treatment for diabetes. So, throughout all of healthcare, diagnosis guides treatment. Now, another way to emphasize this is that we first need to diagnose what the pathology is before we know how to treat it. Well, that's the same thing as saying we first need to identify what the problem is before we know how to fix it. So those terms mean the same thing. So diagnosis means identify, pathology means problem, and treatment means fix it. So we have a problem, parents have a problem, there's a problem in the family, we need to fix it. For that, we're going to need a treatment plan to fix it. So that no matter what the custody decision or is ultimately rendered, what the custody schedule is, we still need to fix the relationship problem in the family, the attachment problem, the problem in the love and bonding between the parent and the child. We need to fix that, which is going to take a treatment plan. No matter what the custody schedule is, we're still going to need a treatment plan. And to get a treatment plan, we're going to need a diagnosis for what's causing the problem. So there's two potential differential diagnoses that can result in severe attachment pathology, a child seeking to flee a parent or a child rejecting a parent. Either one, A, it's the targeted parent who's abusive, in which case, what type of abuse, physical abuse, sexual abuse, neglect abuse, or psychological abuse, we need to identify it and put it on a treatment plan. Or the allied parent is abusive, in which case that would be the child's psychological abuse from creating a shared persecutory delusion, factitious attachment pathology imposed on the child for secondary gain to the allied parent. So that would be child psychological abuse and also spousal or partner abuse of the targeted parent using the child as the spousal abuse weapon. So there's our differential diagnoses that is of concern, and we need a diagnosis to come up with a treatment plan to fix whichever one of those problems is the problem. Now, any diagnosis that's returned into the legal system will be a disputed diagnosis. We know that for a fact because the legal system is adversarial. One party or the other is going to dispute the diagnosis. And the appellate system in healthcare for a disputed diagnosis is second opinion. Okay. So, and this is from Improving Diagnosis in Healthcare from the National Academies of Sciences, Engineering, and Medicine. Clinicians may refer to or consult with other clinicians, formally or informally, to seek additional expertise about a patient's health problems. The consult may help to confirm or reject the working diagnosis or may provide information on potential treatment options. Clinicians can also recommend that the patient seek a second opinion from another clinician to verify their impressions of an uncertain diagnosis, or if they believe it, this would be helpful to the patient. So the threshold for a second opinion is really low in healthcare. It's a good thing. It improves the quality of healthcare services. So you're going to need a diagnosis because we need a treatment plan no matter what the custody schedule is. So let's get a diagnosis for the problem. We have two different possibilities, and let's get consultation because it's going to be a disputed diagnosis. So this is the consultation framework that I would recommend, is that the court designates a primary psychologist to conduct the diagnostic assessment, and then each litigant is allowed to appoint a second opinion consultant through telehealth. That produces our little 3-doctor panel of experts here to do the diagnostic assessment. One's conducting it, 2 telehealth. You see litigant 1 believes it's child abuse by the other parent, and litigant 2 believes is child abuse by the allied parent. So we got cross allegations of child abuse. We get the clinical diagnostic assessment that then leads to the court's decisions on custody, ultimately, though, landing on the treatment plan because we need to fix the problem. This isn't a custody problem. It's a attachment problem. It's a love and bonding problem. So now the consultation on treatment will improve the quality of the treatment provided. So these consultants to the initial diagnostic assessment can then serve as consulting resources for the mental health treatment providers to ensure successful treatment when that occurs. So you can see it goes from the court. Each litigant appoints a telehealth second opinion. We get a diagnostic assessment. What's the problem? We identify what the problem is. We put it on a treatment plan and then move it into treatment. And then those 2 consultants who were on at the time of the initial diagnostic assessment can then also be available for the treatment. So these are the diagnostic questions that need to be answered, yes or no, from a diagnostic assessment of the family in the family courts. First, is the targeted parent abusive in some way? If yes, specify the type of abuse. Second, is the allied parent psychologically abusing the child by creating a shared persecutory delusion in the child? Yes or no? Third question, is the allied parent psychologically abusing the child by creating a false or factitious attachment pathology in the child for secondary gain to that parent? Yes or no? Finally, is the allied parent using the child as a weapon of psychological spousal abuse of the targeted parent? So those are the questions that we need yes/no answers from that clinical diagnostic assessment so the court can make an informed decision and we can put whatever the problem is on a treatment plan to fix it. So part of the difficulties right now, it's called a barrier to treatment, is that there's no diagnostic assessment available to parents and the courts. The diagnostic assessments of the family conflict are currently not provided to parents and the courts by forensic psychologists. They only give the option of their forensic custody evaluations, and you don't want one of those. You want a diagnostic assessment. So, but you can't get one because they don't provide those. And the clinical psychologists who do diagnosis and treatment, they don't work in the family courts. And so they don't know the pathology in the family courts, so they're not competent to do that either. If you get a psychologist who knows about delusional thought disorders, you get one who's coming out of schizophrenia. They don't know about personality disorders or attachment pathology or things like that. And same thing with if you get an attachment psychologist coming into the family courts, they don't know about persecutory delusions. So it's really up to the forensic psychologists to fulfill that role, but they're not. Now, do not get a forensic custody evaluation. That's what you're currently being offered as parents in the courts. Don't do that. They are dangerous. They are harmful to children. They lack scientific or legal value, and their defective reports can lead to potentially disastrous consequences for parents and children. And that was the finding of the New York Blue Ribbon Commission on Forensic Custody Evaluations. They say, quote, by an 11-9 margin, the majority of commission members favor elimination of forensic custody evaluations entirely, arguing that these reports are biased and harmful to children and lack scientific or legal value. At worst, evaluations can be dangerous, particularly in situations of domestic violence and child abuse. It's not me saying this, it's them. In some custody cases, because of a lack of evidence or the inability of parties to pay for expensive challenges of an evaluation, defective reports can thus escape meaningful scrutiny and are often accepted by the court with potentially disastrous consequences for parents and children. So I am that meaningful scrutiny. I get to read them and see them. Do not get one. I agree 100% with the New York Blue Ribbon Commission. They need to be entirely eliminated. However, there's nothing else that you're currently being offered. Now, it is the obligation of the forensic psychologists to meet the needs of court-involved parents and of the courts. The clinical psychologists, they work with ADHD or autism or depression or something else, eating disorders. It's not their obligation to provide the courts with the diagnosis because they don't work in the family courts. It's the forensic psychologists who've chosen to work in the family courts, so it's their obligation to meet the needs of the parents in courts. So it's the obligation of forensic psychologists to conduct a proper risk assessment for child abuse to the appropriate differential diagnoses for each parent. And that's what we have. Potential child abuse by one parent or the other if you got a child seeking to flee a parent. So we need a proper risk assessment going back to that differential diagnosis. However, right now, forensic psychologists in the family courts are failing in their obligation to parents, children, and the courts. And so that's what I'm running into with my consultation clients, with parents out in the courts, with everybody. We need a diagnostic assessment of the pathology to the appropriate differential diagnoses, and parents in the courts cannot get one because the forensic psychologists who should be providing those services to the court aren't. And so that's a significantly broken mental health system that we're currently dealing with. That needs to be corrected. The forensic psychologists need to start conducting these necessary clinical diagnostic assessments. Now, it is also the obligation of the treatment providers, all the treatment providers, to render an accurate diagnosis of the problem, of the pathology, to guide the development of a treatment plan for that pathology or problem. Are they treating cancer or diabetes? So in order to come up with a treatment plan, they should be rendering a diagnosis, but currently in the family courts, they're not. They're just kind of going in willy-nilly and doing whatever, and it's not working. It's failing because they're treating cancer with insulin because they've misdiagnosed what the problem is. However, that's another place where we can get a solution. We can get a diagnostic assessment out of the treatment providers if they elevate to just basic levels of competence and diagnose what the problem is before they start treating it. Excuse me. So now here's a diagram. I like this diagram. This is my image of what a solution for the family courts would look like. It's about treatment, first off, not custody. The family courts land on the wrong endpoint. They land on the decision point for the custody schedule, but we need to fix the problem still. We need to land on treatment as the endpoint, not the custody schedule. And that's what this shows. So we have the court, and then each litigant gets a telehealth second opinion. We get the diagnostic assessment that feeds back into the court's decisions, and that also moves into the treatment plan. And then those two consultants can also consult on the treatment plan, and we make sure it works. Now, there's only two causes of a treatment failure. One is you've misdiagnosed the pathology and you're treating cancer with insulin, or two, you've accurately diagnosed the problem, but you are incompetent in delivering the intervention for that pathology. Because if your diagnosis is accurate and you're competent in delivering the treatment for that diagnosis, then your treatment will be successful. Okay, so if we move into the treatment phase and we're not seeing a good response to treatment, then that would suggest our diagnosis was wrong. We go back in and look at the diagnosis and see, correct that, or see what we can do about making treatment successful, because it needs to be successful. This is an attachment pathology. The attachment system is a primary motivational system of the brain developing its patterns during childhood. We need to fix whatever the problem is. This is a treatment problem, not a custody problem. The pathological parent drives this into the wrong system for a solution. They drive it into the legal system, but everybody fights about the pathology and they can manipulate the legal system. Machiavellian manipulation, dark triad, vulnerable dark triad, dark tetrad. We need to get it out to the healthcare system where it belongs, and then apply, diagnose it, and then treat it and solve it. The pathological parent won't want that. They want the pathology. They don't want it treated. They will work very hard to keep it out of the healthcare system. They are currently getting collusive participants in the forensic psychologists who've taken on a quasi-judicial role instead of a clinical role. They need to return to being clinical people and giving the courts and parents a diagnosis and treatment plan for the problem. So with that, that's my Sunday morning coffee describing what the treatment protocol is, and that's just kind of the way it is. And until we get a diagnosis and treatment plan, you're going to have a problem in the family courts. We can fix it as soon as we diagnose what the problem is and put it on the treatment plan. So with that, I'm going to head off to the rest of my Sunday. Excuse me.